Welcome back to the Law Show. Bob Kerrigan with you from our broadcast studios here. Kerrigan, Estes, Rankin, McLeod, and Thompson, the sponsors of this program. I'm one of the partners with the law firm. We've been here in the North Florida area, Northwest Florida primarily, but across North Florida for years, and have established a practice that focuses on trial work, and that's in the courtroom. That's where we are with our cases, and our cases generally involve serious injury or death claims. I've said this many times in the past that years ago you had to pay a lawyer, had to give a lawyer a retainer, a certain amount of money to prosecute your case. In today's environment, the cases are expensive, especially medical malpractice cases. They're just very expensive. And so our firm has decided that we will advance all costs of these kinds of cases, and we will not expect reimbursement for those costs unless we make a recovery, and we won't be paid until we make a recovery. We don't send the clients bills as the cases are progressing. And when the case is concluded, we expect to be compensated according to the contract that we enter into with the client. The contract we use is a contract that has been approved by the Florida Supreme Court, and it provides a percentage of recovery depending upon various stages of the case and the amounts of money involved. The greater amount of money, the lesser the percentage recovery for the lawyers. So in multi-million-dollar cases, it's much less than it would be in a standard contingency fee case involving a typical automobile accident case. You have a right to understand everything about what the lawyer is going to do, what kind of experience the lawyer has, what kind of training the lawyer has, the reputation the lawyer has. All these questions should be asked by you. The Florida Supreme Court has done a good job, I think, in establishing a list of clients' rights. These are rights that you have before you talk to a lawyer to make sure that the kinds of questions you are asking the lawyer, that you get good answers that allow you to make an informed decision. We don't charge anybody for consulting with them about a case, and we don't create a sense of obligation. So as soon as they come into our office or see us, we hand them papers to sign. I mean, we are the lawyers. We know what these contracts mean and what they provide. So we like to give them to the client, give them plenty of opportunity to look over it, read it, try to understand it, ask any questions they have. We will write on a contract itself anything that they want us to write on the contract that allays any fears they have about the fee that they're going to have to be paying at the end of the case. We try to do this in a way where we never have a conflict with the client at the end of the case, because when you work hard and you worked on a case a long time and you get a good results, you want it to be crystal clear what the compensation is going to be and what the client is going to receive. When we go to a mediation, we have talked here on the Law Show about mediation. That's basically an informal conference where you try to settle the case. Before we end mediation, where there's been an offer, we will put in writing what the client is to receive as a result of that offer, so that there isn't a situation where you reach a settlement, say the settlement is $100,000, and then later the lawyer explains how he's got additional fees or charges or costs or something that you didn't know about at the mediation, and therefore your percentage will be less than what you thought it was. We don't do that at mediation, and I highly recommend this to any of you that are going through a mediation with a lawyer. Just explain to the lawyer that you want to know in writing. If you agree to a settlement, you want to know in writing with the lawyer's signature and your signature what you will receive. In other words, what will the check be that I'm going to receive? The lawyer should provide that to you before the mediation is over, so that in mediation you're going back and forth discussing settlement, trying to figure out what we can resolve the case for, what the other side is willing to pay, what you're willing to receive. and you come up with a figure, as I said earlier in that example of $100,000, you need to know before you walk out of that mediator's office how much your check will be. And you can tell the lawyer before you go to mediation that that is something that you're going to want to do. You're going to want to have that in writing. We do that routinely because when people go through the stress of one of these cases and you get near the end and you've settled the case and people are satisfied, usually mediation, nobody's really happy about it. The other side paying more than they want and the person is really receiving probably less than they had hoped to get, but it gets settled. It's over. You have a sense of relief and the stress that you've been through going through the mediation process, going through the litigation process. You should know exactly what you're going to get paid, okay? And in the final payment to you, there should be a distribution sheet that will, or page, that shows you precisely what the costs were in the case, what you are paying to the lawyer in terms of a fee, and then that figure at the bottom, the net figure, will be the figure that you were told in mediation you could expect to receive. Okay, so that's how that works. And just for those of you who are going to go through mediation in the future, I hope that helps you some, because confusion about money is not good. And lawyers are obligated to make sure there is no confusion about the amount of money that you're going to receive, because it's your case, not the lawyer's case, it's your case. But I want to make a couple of comments now with the time that I have. I've talked in the earlier session about how we are going to continue to try to understand this Medicare thing and to understand the complexities of it, why the government does not have a sensible way for you to read all of these plans online in writing. If you try to find these plans in writing, you can't find them. We're going to explore that. We're going to explore why private insurers are involved in Part D, these drug plans, why that wasn't undertaken by Medicare. My fear is that private insurers are going to completely take this over, and that these policies will be so confusing that people are going to sign up for them and not realize until it's too late, until they're in a claim, that they are in the wrong spot. Okay, we talked about the highly misleading commercials that have been run. Many commercials, I think, are not misleading about healthcare advantage plans. They say pretty straightforward, this is our plan. We're going to provide that. We're going to provide drug coverage. We're going to quote you a premium and all. The problem is the public doesn't understand the complexities of this, and to understand that you're not getting Medicare. You're getting something else. You're getting a substitute for Medicare. But what I want to address now, and it preys, I say on the elderly, I'm one of them, so it's not like picking on a group that I'm not a participant in, but I think it's difficult for people who don't have any experience with this to really understand the options that are available and to make an informed decision, because you don't know what kind of illness or disease you're going to have. And that's the whole problem with these Medicare Advantage plans. You do not know what you're going to run into to see how it's going to be affected by the policy you've purchased. But I've talked about that some earlier today in the last couple of weeks. By the way, and I am so appreciative of those who've taken the time to send us a text message, or text me right now. We'll answer your text messages while we're on the air. It's 850-444-4444. That's our phone number too. You can reach us in that phone number, but for texting, you have to do the 850 before there. So I want to talk about just the whole industry of the exploitation of the poor and of the elderly and disadvantaged and people who are not able to sort through what's being said to determine what is true. Let me give you an example about an advertisement. So this company, they sell furniture and they advertise no interest till 2022. Great, no interest. So you kind of run it through your mind. Wow, I have no interest, and so every payment I make will be knocking the principal down. It's just great, okay? But in the fine print, they tell you that if you are late, interest accrues immediately. and there is no free interest. You've lost it. And so you send a payment that's late, you're short that month, you had to take care of a vet bill or, something for the kids or whatever, and you send it late. Now you're back into this awful interest that they charge. And I mean, some of it is just prohibitive in terms of the amount of interest compared to, say, what you could borrow from a bank. So you have to understand that what's being advertised as free is never free. It's never free. It's always got a hook. You say, well, yeah, but if you make your payment on time every month and you never miss, well, that's true. That's a fact. In that case, maybe it is free, all right, at least for that period of time. But most of the time, there's a little hook of some kind in it. But to me, the most egregious thing that is going on for exploitation of the poor, and you can judge the poverty of a community by the number of payday loan stores and title loan stores. You judge a community's poverty level by the number of those. It's a pretty good indice of how poor a community is if you see a lot of these payday loan outfits and title companies. There's a commercial going on right now that people are jumping up in the air and they're waving their hands. They're so happy they got their title. They say, I got my title back from so-and-so. I got my title back. I got my title back. Well, what does that mean? It means that they've paid a loan off to get the title back. Well, what are the loans amount? Okay, up to $2,000, 30%. $2,000 to $3,000, 24%. Over $3,000, 18%. And these are virtually guaranteed loans because you've given them the title to a vehicle that's worth 3 or 4 times what they're loaning you. And these interest rates are 30%. Okay? You want to go borrow some money from a payday loan place? You got somebody working hard, making $8, $10, $12 an hour, whatever they're making. They get a loan up to $1,000. The actual interest rate, 304%. 10% for every $100. Preying on working people, preying on the elderly, preying on the disadvantaged. I don't understand why churches and nonprofit groups don't establish for our working people advance payments against paychecks from legitimate companies so that people that are working so hard don't get faced with these high interest rates because they're short of money for the kids or for Christmas or for a doctor bill or for gas or whatever they need. It just would be wonderful if we had nonprofit groups take a look at this in our community and try to help people who are helping themselves and working hard but being exploited to the point of these enormously high interest rates. So I hope you'll think about that and send any comments you have about subjects that we can cover. We welcome contrary opinions too. We're not happy about them, but we'll publish them if you send us a contrary opinion or a view that is different than what's been expressed here. Bob Kerrigan for Kerrigan Estes, Rankin McLeod in Thompson. You can reach us at 850-444-4444 by text. And that's it for this segment of the Law Show. We'll be back after this commercial message.